right, let me get my wind up. Summary of unlicensed, and just so you know, I grabbed this from, and I'm going to have the source for you, but basically this is a document that was produced by the state of Florida, and it had a list of a bunch of different professions, because sometimes the line between doing your job as a skilled practitioner versus the unlicensed practice of law can be a little gray. So what they did was they say, we want to put this out there just so you understand, depending on what you do, what we consider unlicensed practice of law. And this is what it said. A summary of unlicensed practice of law cases. In order to determine whether an activity constitutes the unlicensed practice of law, a two-part analysis must be made. First, it must be determined whether the activity is the practice of law. The second question is whether the practice is authorized. If an activity is the practice of law, but the activity is authorized, the activity is not the unlicensed practice of law and may be engaged in by a non-lawyer. The Florida Bar v. Moses. The first question, which must be addressed in order to determine whether the service or activity constitutes the unlicensed practice of law, is to determine whether the activity constitutes the practice of law. Continue. In the Florida Bar v. Sperry, the judge vacated on other grounds. The court found that setting forth a broad definition of the practice of law was nigh to impossible, and instead developed the following test to determine whether an activity is a practice of law. If the giving of the advice and performance of the services affect important rights of a person under the law, and if the reasonable protection of the rights and property of those advised and served requires that person giving such advice possess legal skills and knowledge of the law greater than that possessed by the average citizen, then the giving of such advice and the performance of such services by one for another as a course of conduct constitutes the practice of law. Based off of what I just read, or what I just stumbled over, is assisting an insured with a sworn proof of life, sworn proof of loss, the practice of law? Anybody? You said no? Anybody say yes? I think it is.
I would agree that it is, but it's authorized, so it's not unauthorized practice.
You putting the cart before the horse. I'm getting there. So, like I said, it's a two-part test. First, you got to determine if it's the practice of law. And we just said that most insureds cannot satisfy those duties after a loss. And those duties after a loss require you to do the signed sworn proof of loss. And it requires you to have knowledge more than the average citizen. So I will say, in my opinion, that assisting an insured with a signed sworn proof of loss is the practice of law, because if it isn't done right and correctly, or if it isn't submitted at all, you just barred a lot of their rights. All right. When applying this test, it should be kept in mind that the single most important concern in the courts defining and regulating the practice of law is the protection of the public from incompetent, unethical, or irresponsible representation. Now, some of y'all have y'all opinions about your peers, colleagues, and associates. But I will say that for the most part, public adjusters aren't incompetent. For the most part, they aren't unethical. They're not irresponsible, right? The Florida Bar v. Moses also, although a codified definition does not exist, there is a large body of case law applying the Sperry test to determine whether a specific activity constitutes the unlicensed practice of law. Therefore, although one cannot go to one particular source, such as a dictionary, for a definition, in most instances, whether an activity constitutes the unlicensed practice of law can be found in case law. Now, it said all that to say this. It did this whole list, and if you want to see the whole list, please check out that source at the bottom. It did this whole list, and in that list, it included insurance adjusters. And it said, if you are an insurance adjuster working a claim in the state of Florida, and you want to know what constitutes the unlicensed practice of law or just something that you do as a part of your job, you should read. It says, Insurance Adjusters Florida Statute 626854 sets forth the definitions and prohibitions on the activities of public adjusters. Basically, a public adjuster may represent an insured in negotiations with their own insurance company on matters involving property damage. The public adjuster may not negotiate on matters involving bodily injury or represent the parties in court. So it just said, as long as it's not bodily injury, as long as you're not representing them in court, and it isn't specifically prohibited in the Florida Public Adjusters prohibitions, then it's not the unlicensed practice of law. So if you want it a little bit more pretty, here's it set up. All right. So I took a couple things out of the public adjuster prohibitions for people working claims in Florida. And because it exists in Florida, it may exist in your state as well. 12A, each public adjuster must provide to the claimant or insured a written estimate of the loss to assist in the submission of a proof of loss or any other claim for payment of insurance proceeds within 60 days after the date of the contract. The written estimate must include an itemized per unit estimate of the repairs, including itemized information on equipment, materials, labor, and supplies in accordance with accepted industry standards. The public adjuster shall retain such written estimate for at least 5 years and shall make the estimate available to the claimant or insured, the insurer, and the department upon request. An insured, so first off, let me ask you, as public adjusters, are you sending the estimate to your insured before you send it to the insurance company? Yes. If you're not, you should. And are you getting them to respond verifiably that if something should be added or removed from this estimate? If you're not, you should. But definitely if you're not, this is very important for you to read. An insured may cancel the contract with no additional penalties and fees charged by the public adjuster if such an estimate is not provided within 60 days after exceeding the contract. Did y'all know that was in the statute? That if you don't get them that estimate within 60 days, they can just, and you work for them for 60 days, they can just cancel your contract with no fees? Subject to the cancellation notice requirement in this section, unless failure to provide the estimate within 60 days is caused by factors beyond the control of the public adjusters. Anybody ever read that in their statutes or in their policies, that factors beyond the control? Usually they say beyond the control of the insurer. Anybody ever read that? Yes, no? Do y'all know what that means? So, and I'm going to tell you specifically what it means, because some of you have gotten that excuse before. Somebody would say, well, it's factors beyond our control. If it isn't this specific thing that I'm about to show you, then you have some recourse for you and your insurer. All right. A company employee, and this is also in the public adjuster prohibitions, a company employee adjuster, independent adjuster, attorney, investigator, or other persons acting on behalf of the insurer that needs access to the insured or claimant or to the insured property that is the subject of a claim must provide at least 48 hours notice. Anybody have an insurance company say, hey, we need to see the property right now. We need to see it tomorrow. They have to give you 48 hours notice. And if they do not give you 48 hours notice, the insured or claimant may deny access to the property. And if you want that source, check that out. And if you want it more pretty, there it goes.